Hi there, I'm Brian Simo, lawyer and partner with Ross McBride in Hamilton, Ontario. Today, let's talk lawsuits. So lawsuits. This is a topic most of us are familiar with, but don't actually fully understand. So what does a lawsuit involve? When you come into a lawyer's office and you have what we call a cause of action, which is the allegation you're going to make that makes up the lawsuit. And that could be something like a car accident, a slip and fall event, or breach of a contract, or wrongful termination. A lawyer will often do quite a bit of investigation with them and their team to find out the details of what happened before any action gets filed. We use the term lawsuit and action pretty interchangeably. It's the same thing. So what types of thing is your lawyer and their team investigating? Well, depends on what kind of action or lawsuit you're bringing. If it's what I do, a personal injury action, we're usually looking at things like medical records, police reports, property damage files from a car accident. Another important thing a lawyer will do at the beginning is put the other party on notice. That doesn't actually start the lawsuit. It just notifies the parties that one is going to commence. In Ontario, there are various statutes, meaning laws, and regulations around when parties need to be put on notice. Party in a lawsuit doesn't refer to some shindig. Party refers to an entity or a person involved in the lawsuit. A party can be a person, so for example, the driver of a car. A party can also be a company, for example, a company who owns a property that you fell on. Party can also be His Majesty, which is what we call the government. Once the parties are identified and your lawyers put them on notice, you're prepared to file what's called a statement of claim. A statement of claim is the document that actually starts the formal lawsuit in court. It's drafted by your lawyer and filed with the courthouse. Now, the statement of claim contains what are called allegations. These aren't facts, they're not proven. The defendants will usually file what's called a statement of defense. A statement of defense is their response to those allegations. Both of these documents form the outline of the lawsuit, what's relevant in the case, what's going to be argued in the case. However, it's important to know that allegations made in either of those documents are not facts. They are not proven in court. They're simply allegations. Once that process is completed and all the parties have responded, the next thing that occurs is what's known as documentary discovery. There's a misconception that lawsuits involve surprise witnesses, surprises at trial, secret documents. That's usually not the case. In fact, that's very unusual. Cases involve full disclosure of witnesses, evidence, and information to the other side. And what that means is there really are no surprises. It's one of the reasons very few things go to trial. Everyone knows what most people are going to say if the case did get before a judge or a jury. So documents get exchanged by both parties. After that's completed, the parties will proceed to what's known as examination for discoveries. This is where you're going to sit in a room or on a Zoom call with your counsel present, and the lawyers for the other parties are going to get to ask you questions under oath, meaning you're sworn to tell the truth. They can ask you any question that is relevant to the case, and in some cases, that is a very, very broad purview for questioning. You can imagine if you make an allegation that injuries from an accident have affected your ability to enjoy life, it makes a lot of your life relevant to that allegation, and you can be asked questions about it. Once examinations for discoveries are completed by the parties, typically what occurs is the matter will be set down for trial. That involves simply filing some forms with the court and getting scheduled to be put on a trial list. Before your case goes to trial, you are going to have an opportunity with your counsel to sit down at a pre-trial with a judge of the Superior Court, where they will make sure the matter is actually ready for trial, and in most cases, put quite a bit of pressure on the parties to try to resolve the case before it ends up in court, if the parties are both being reasonable. But some cases do go to trial. Some cases have to go to trial. The parties just can't see eye to eye. When that happens, trial happens in a courtroom. There's a judge. There can be a jury. Not every case involves a jury. And witnesses are called, evidence is given, and the court, the judge, or the jury deliberates, and it comes to a conclusion and a decision. And that's the end of the case. Now, let's talk a little bit about what happens to most cases before they get there. As I've alluded to several times, cases usually resolve well in advance of a trial. In fact, at every single stage I just mentioned, there are opportunities to resolve lawsuits. And the vast, vast majority of cases do not reach a judge and a jury. So what do you do now? Well, if you have an issue that you believe gives rise to potential litigation or a lawsuit, you need to speak with a lawyer as soon as possible. If you think you have a cause of action, feel free to reach out to me or a member of our team. Our contact information is below, and we're happy to speak to you anytime to see what we can do to assist. Thanks, and have a great day.